I'm Andrew Andronikou, a restructuring partner in Contuma's London office, and I will be your host and chair for today. This morning, we'll be taking a look at the challenges in the retail, food and beverage sector, discussing the possibility of bringing back to life this sector through a restructuring of leases. To help us do this, I'm joined by a panel of experts operating in the legal, restructuring and insolvency professions, as well as in the commercial property space. I'll introduce you to our speakers shortly. But before I do so, I'd like to remind you all that the Q&A function is open on the webinar, so please do feel to submit your own questions in real time. We've also had a few questions submitted beforehand, and we'll try our best to answer most of these at the end of this session. If there are any questions that we aren't able to answer during today's webinar, we will endeavour to do so outside of today's event. And so without further ado, let me introduce you to our illustrious panel. Our first panellist is Mr. Vernon Dennis, a partner at Howard Kennedy. Vernon is a highly experienced specialist in business transformation with over 25 years experience designing and implementing financial recovery and restructuring plans for business clients. Vernon is Head of Business of Recovery and Restructuring Group at Howard Kennedy. He advises insolvency practitioners, creditors, debtors on a wide range of corporate recovery, reconstruction and business rescue issues, both domestically and cross-border. He specialises in strategic and advisory support for company boards when planning programs of business turnaround, restructuring or transformations. He has extensive experience in retail and restaurant distress and cases known for their technical complexity. That was a mouthful, Vernon, wasn't it?
It certainly was. Thank you very much, Andrew. Thank you for the introduction.
Our next panel member is David Abramson, Chief Executive Officer of the Cedar Dean Group. David is one of the most widely known and respected leisure advisors in London. With over 20 years in the business, he has built a reputation brokering corporate property acquisitions and disposals of the highest calibre, and over the last 12 has built up a leading lease restructuring practice. He has worked with clients such as Nobu, Novikov, Cipriani, Novus, and the list goes on. I could be here all day. Welcome, David.
Thank you.
And finally, and not least, we have our very own Brian Burke. Brian is a director in our restructuring and insolvency team. He's also an integral part of the Brighton office management team. He is an appointment-taking insolvency practitioner and has indeed joined me on a number of cases and has been advising this management and stakeholders of owner-managed mid-market businesses for over 10 years. He has extensive experience on working with a large number of individuals and businesses across a wide range of industry sectors, including manufacturing and retailing. Now, without a further ado, I think I should set the scene for the discussion. I'm an entrepreneur with two investments in retail and in casual dining. I have a number of units of multiple locations, mostly city-centred. My businesses were both successful. However, in March, due to government guidelines, I was forced to put my businesses into intensive care, cease trading, and now find myself in a position where I have not paid March rent, June's rent. I have a plethora of trade suppliers knocking my door, and I want to speak to my landlords, but no one's answering the call. David, what should I do next? Some practical solutions.
Yeah, I think that it's important to say that that these problems didn't start on the day that lockdown happened. I think that's the first thing to understand. This is not a, oh my God, the world woke up and rent was a problem. I think the market's been broken for a long time because rents have been unsustainable, and the relationship between landlords and tenants has been that landlords as a general class have been looking at tonality, which is pounds per square foot, and operators have been looking at affordability. What can I afford to pay? And as long as those two things could coexist together, there wasn't a problem. you can call it whatever tone you want as long as I can afford it. Unfortunately, what COVID-19 has done is just completely obliterate those two things living in the same space, and obviously rents are completely unaffordable. In terms of solutions, almost certainly, as you mentioned, tenants like the ones you suggested will not pay June, not because they're bad people or dishonourable people, just purely because survival will come ahead of reputation. This is a economic war. A pandemic has caused obviously a big impact on business, and therefore the only way for a landlord to feel the same issues as their business or tenant is for them not to pay the rent, and then at least there's a conversation where they're both feeling the same things. Once that obviously happens, really tenants can't just sit there and not pay rent. They need to put a plan together, and I think that's where advisors like yourselves come in. What's the art of the possible? What could be done? But the idea that things can stay the same or in the same corporate structures, I think is unlikely, certainly as a plan B. Once they've got that advice, it's really time to execute some real restructuring. Obviously, there's a lot of talk of turnover rents, and anyone can come up with a number of flowery schemes. I'm sure there'll be some questions about that. But ultimately, it's all about affordability and landlords losing and changing their focus away from, what the tone of that area is. And certainly looking into the future, we must eliminate these upward-only rent reviews, because they have caused a lot of toxic over-rented property, which we're now all seeing. But I think that if you're a business owner, you do this on your own. You need a team around you.
Okay, in this example, during this hiatus period, I've got the benefit of this moratorium put in place by the government. But I am aware that shortly that moratorium may come to an end, and there may be other tools, other insolvency processes available, not that far ahead. Insolvency bills have been muted. In terms of, from a legal point of view and from the insolvency toolbox, what should I be doing?
Yeah, Andrew, shall I take that one? I think the first thing to bear in mind is that we have a moratorium, as you put it, only in as much as there's the legislation which prohibits the landlord from forfeiting. And that was for the non-payment of the March rent, and it's likely to be June as well. We're waiting to hear that. So a landlord is prevented from forfeiting for non-payment. That's not the problem generally for your high street or for your hospitality industry, because the landlord doesn't want the premises back. What became the next battleground, certainly that I saw during April, was the non-payment of March. The landlord didn't actually want the premises back, but they would attempt to recover their monies through winding up petition statutory demands and putting tremendous pressure to the payment. Very often the landlord's sort of saying something along the lines of, well, you were trading up till March, you must have the money, why can't you pay me? And therefore you're insolvent. So what then happened was the second wave of effectively government measures, the temporary stuff, which prohibited the use of winding up statutory demands and winding up. One has to say, however, that at the moment is still a bill. It still hasn't come into force. We're still waiting for it to come into law. But the courts are certainly giving effect to the provisions and are injuncting landlords who are seeking to wind up companies. So effectively, and I use those words very advisedly, effectively, the tenants do have a moratorium during this period, and we're waiting, and we will be talking further about the other provisions which might provide more permanent solutions.
Ostensibly, this virus, this pandemic hasn't offered many benefits, but my business comprises of a number of units, multiple units, as we said. I have, unfortunately, structured them in one company. Within that company, I refer to them as dogs. I have a number of leases that haven't been working for me for the last 2 or 3 years. But I also have some valuable leases that I don't want to leave, or lose rather. So given where I am and the consensus that my business may now be subject to insolvency proceedings if and when the moratorium is lifted, what can I do? how can I address those, and what processes are available to me, consensual or otherwise? Brian?
Well, I think the first thing to do is take a good hard look at your business. It's about making it fit for purpose. I don't think there's a business out there that can continue to support its loss-making elements or the areas that are actually drain on cash. At the moment, your cash and liquidity is going to be absolutely crucial. If you had a viable business, it's been frozen in time. You've accumulated additional liabilities, and that's just to get to this particular point. When you move forward from here, one would like to think you can engage in a constructive discussion with your key stakeholders, your landlords, your lenders. Look at the facilities the government's made available. I'm sure you've taken advantage of them, using the furlough scheme, look to C-bills, etc. But if you can't reach a consensual agreement that allows you to get onto a firm footing, then it really comes down to, okay, so what are your next options? So it could be a company voluntary arrangement. We've seen those extensively used within the retail space and more being announced today. There's obviously the new Corporate Insolvency and Governance Bill, which, whilst it's not enacted as yet, will come into force in due course. That presents a moratorium, allows directors to restructure. And there's a new restructuring plan, which could become very effective for a viable business. And also, whether it's insolvent or solvent, that can be utilised. Worst case scenario is preserving the business and assets through an administration in one shape or form. But at the moment, it's more, in my view, an opportunity for you to take stock, sit down, repurpose your business, work out what it's going to look like going forward, and try and get your stakeholders on board if possible.
Okay, well, I have got my C-bills. I've got my bounce back loan for what it's worth. I've got some cash in the bank. What sort of deals have been done? I mean, from your experience, David, have you achieved anything in the last 2 or 3 months with anyone, or have, as in my case, landlords just not picked up the phone to me?
Look, we started lease restructuring in 2009 when we felt a much smaller but similar problem, which has meant that we're doing this a long time and understand the lay of the land. And we're currently dealing with about 800 properties, and we have done countless numbers of deals. And actually, I'll be honest with you, when a company director is clear about what they want, and they can communicate that via us or directly or however they want to that landlord, then the landlord, and it's transparent and open and backed up, then landlords will hear it and see it, because almost it's much better to do that than face a more, as Brian says, it's the time to talk to your stakeholders rather than, because otherwise, obviously, what we've seen with the CVA, the proposals for TRG, I mean, that's potentially catastrophic for landlords, looking at a 70% potential drop in capital values. I mean, that's enough to shudder any landlord or bank. So, better to have a really a good discussion. So yes, we are doing lots of deals. A lot of them are via side letter, so they can be done on literally over DocuSign in a matter of days. Some of them are short term, so they might be 6 months rent free. Some of them are, let's look at the 2-year predicted period, so it might be 6 months rent free, 12 months half rent. Some of them have got a turnover element, but obviously they're difficult to document. But every day deals are being done, but you have to have clarity on both sides to get them done, and a focus that timing is essential.
Look, I love the idea of doing a consensual deal. It means that professional costs are a minimum, effectively, but I'm having difficulty with my landlords. Traditionally, they've never really engaged with me. It's always been the fact that I've had to adhere to their demands. I do feel that now that the tables have turned. Vernon, I know that there's legislation afoot that's going to simply assess me. I'm not too sure when it's going to be effectively enacted. I'm told I might need some sort of bridge, an air bridge too, when that bill is put into place.
Yeah.
What can I do?
Yeah. Well, I'll pick up really from David's point, which is the first thing is that a lot of landlords are agreeing and coming up with consensual restructuring deals with their tenants. Where the problem that you have is if you have a minority of your landlords who won't do a deal, you have a problem. Two aspects of following from this, and one I'm seeing from experience is the tables have turned to a large degree. Landlords have their own problems now, and the non-payment by tenants and the difficulties of their tenant portfolio is causing landlords to be in distress as well and potentially breaching their covenants. And there's a bit of a play here going on that landlords might prefer simply to defer or give a rent holiday for a year, 2 years. And I think that's kind of deal that David's seeing quite a lot of, and we're being able to agree that quite easily. The big restructuring part of your lease to change it forever is more difficult. And as you're right, the CVA, David's referred to that, and the TRG one, which comes through, it sort of seeks to impose upon the landlord community a significant rent reduction. The key, however, on CVAs and the way that it's worked out in the last few years, and particularly after BHS, is that you can't effectively force a landlord to take something they don't want. That's why you give them effectively the break within the CVA, that, you know, if they have a choice, they either accept the significant rent reduction or whatever terms are there, or they take their property back. And they sort of given license, because if you don't give them that opportunity, if you seek to bind them, which is entirely possibly legally, you may well find that you're challenged as one of unfair prejudice, which we've seen, you know, obviously in House of Fraser, which collapsed, the CVA collapsed on the basis of that. And we've seen the BHS in particular was another one which had already failed, but that's where we get our legislation from. So there's quite a lot of attempts, if you like, to think about how best do I bind in my dissenting landlord community. And I'm going to actually go a bit further here. When we talk about the new Act, it will come into force, I think, probably next month, we're hoping. It's got through the committee stage of the House of Lords, so it's really on its way. The House of Lords gave a few sort of indications that they were slightly concerned about the permanent measures not being properly debated, but have basically thrown that back to the House of Commons. And these permanent measures, and this is the point, the permanent measures, as Brian's already indicated, are the moratorium and the restructuring plan. And the moratorium really does no more than provides a further opportunity. And I think it's the bit that you're talking about, Andrew, there, the bridge that might go the next part into the next quarter or otherwise, an opportunity to have a formal moratorium process while you'll get then having a further debate with your landlords. So that sort of provides that. But it's still fundamentally keep coming back to the problem of, you know, you can negotiate with your landlords, but I don't see the courts forcing landlords to change their terms. And this is an interesting one. I have some overseas clients who are absolutely amazed that the courts won't intervene and strip out rent. They say, well, how you know, this has to be unfair, surely. In our jurisdiction, we're able to effectively cram down and vary the terms of a lease. And you go, well, in the UK, that's just not, we don't have the same. We have a fundamental, you know, if you agree your contract, you're bound by your contract, and you can't force someone to vary terms. And I keep coming back to that point. And that's a fundamental problem that we're going to have to deal with in the years to come, not just the months to come.
So I understand, Brian, that I've got more options than an administration order. I can't see how an admin order helps me. I've got some cash. I don't necessarily want to give it to an IP, and then effectively sort of play, risk losing my prime sites with the sites that aren't working. So how do I get from A to B? How do I get from here to when this innovative insolvency legislation is enacted?
I think the first thing, you mentioned prime sites and other sites. You don't know how those prime sites are going to perform going forward. There's complete uncertainty over where your top end revenue stream is going to be. I think one of the fundamental issues that are going to have to be addressed over time, because that's the only thing we can actually work through, is at what level are you going to be able to pay a sustainable income to your landlord? That will have a direct impact on them. So hence I fully understand the reason why people are moving towards turnover rents. If you don't know where your top line is, how can you work out how you can possibly afford a particular base rent? That obviously has a direct impact on the landlords themselves. I'd also say that something that I think is always worth remembering is that each business, and probably every business they deal with, has had an impact from COVID-19. This is the entire supply chain. This is the entire, whether it be your meat supplier for your casual dining business, whether it be your staff, whether it be your landlords, and your banks, your bankers, their bankers. Everybody in that cycle has had an impact, and they're all trying to manage and deal with it effectively. The one thing that obviously you do need is some degree of certainty, a solid platform to move forward. Now, if you can obviously obtain creditor support, a CVA is a good way of achieving that, especially where you have obviously a proportion of your, whether it be landlords or creditors who are dissenting. The new corporate governance, corporate insolvency and governance bill, brings with it the restructuring plan, which effectively allows you to divide your creditors into their individual classes. So landlord will be one class. And the idea is that you get 75% of each class of creditor to approve. If one class is dissenting, then it's possible to take that to the court, and the court will decide on whether it's in the best interests of the parties that your restructuring plan is put forward. Now, as far as I understand it at the moment, there is the possibility that the outcome is going to be defined based on what is the alternative for that class of creditor. In the landlord's position, the alternative is you go into administration, they potentially have an empty store, or they certainly don't have any income, and they actually have a direct loss of all the arrears that have been built up. So there's arguably a compelling reason to, as long as it's fair and equitable, to take a view on what is the right approach. And I think some of that gets drawn from the discussions that people should be having now with their landlords and their creditors, to try and understand where their appetites and their issues are.
Yes, look, it's all very well. My casual dining business is now a takeaway business. My retail business has no footfall, and I have no idea of projecting when that footfall is going to return. I'm looking for practical steps, David. It's obvious that talking to landlords, no landlord currently is willing to set a norm, or are they?
No, I think that every single landlord is different, and within those landlords, every deal has been different, and we've seen so much. But there is, thankfully, huge amounts of creativity that is coming out of this. For example, if there's a rent deposit in place, using that rent deposit. So let's say there's a 3 months rent deposit in place. Saying, I'll tell you what, take my rent deposit, don't ask to top it up again. And then maybe give me 6 months or 9 months rent free. So the landlord's taken some monies down, which maybe can help with some mortgage payments, and that helps but they've given a bit more from that. That's been a solution that we've seen. I think that there's lots of ways of dealing with it. I think that the problem has been, I would say, between March and June, is that it's been such a moving feast, because it's gone from the Asif Aziz's aggression, unacceptable aggression on tenants, which I'm sure all landlords wouldn't want to adhere to okay, yes. And then I would say the middle of the quarter was all about deferrals, and now it's all about, okay, let's do something for March. And I actually spoke to one landlord this week, and they're like, now that they were almost at the at the end of June, they're like, oh yeah, we know we're not going to get paid March. So the longer this goes on, it's not getting better for the landlord community. So it's kind of like, but the truth is that all the tenants that I represent, a lot of them are very very respectable people, and they're just trying to do their best. Obviously been caught in the head, some headwinds here, significant. And once they've done their deal with their landlord, they will do their best to honour it. So the quicker that these things kind of get sorted, the better they are. And I'd say it could be rent freeze, it could be turnovers, but I think the key is now, stop thinking about March, stop thinking about June, start thinking about the next 2 years, because the next 2 years is we're going to be living with this thing, pretty much certainly, and therefore make a longer term deal. That's what we're trying to do at the moment.
Absolutely, and I find myself being in the same position as the landlords. I don't want to do a deal with the landlords now because I don't know what's going to happen in 3 to 6 months. We're already talking about a second wave. We haven't got over the first wave yet. So I'm completely, at the moment, at a loss what to do. I know that I need to do something. I'm trying to look at preserve cash, but looking at what the government's trying to do to me, they're trying to open my business up ahead of schedule. The furlough scheme seems to be coming to an end in the next 2 or 3 months. That means I've got a huge decision to make. Almost, I have to make a gamble at some point to decide what to do with my business. So from a practical point of view, how and when should I start looking at my restructuring plan? I presume you're going to say to me now.
Well, actually, even about 2 months ago.
Okay, well, I need to start today.
Yeah, let's say it's never too late. So why not
Yes.
now?
Yeah, the earlier the better.
So what I'm looking at, the 3 components to my business: my employees, my landlords, and my supply chain. My supply chain, I understand, can't actually do anything to me at the minute because of the moratorium. And effectively, I understand, Vernon, that the government may cast a larger shadow with that to enable the bill to come through. Is that correct?
Well, there's two elements really about this as well. Is cash flow management as well. For any business at the moment, they're going to face some significant problems about cash flow management and the issue of the shadow of insolvency. The failure to pay the rent and the inability to pay the rent is one problem. That's what we've been discussing today. But it goes more fundamentally into the whole business. The business is itself potentially insolvent, either on a cash flow basis, in all likelihood, and the deferment of the debt doesn't really solve much because it just pushes you into the balance sheet problem. So you are insolvent, and I'm going to say this, I'm a lawyer, but I certainly think that directors have to think very carefully about their duties, responsibilities and obligations that they have, not just to their creditors, to act in the best interest of their creditors as a whole, but to avoid personal liability if it all goes wrong. And that's something that I'm providing a tremendous amount of advice at the moment about. What do you do in these circumstances? And just going to the supplier issue, this is a big issue for businesses that are having to restart. They're trying to preserve as much cash in the business as possible. That means they're going to not pay certain creditors. Now, that in itself potentially puts them at risk, significant risk. The fact that they are preferring to pay their suppliers, for instance. And maintaining your supply chain is absolutely essential. Because when you do restart your business, when demand comes back, you need those suppliers. So there's been a lot of discussion about financial Darwinism. If you are effectively just out to survive for yourself, you will kill off a number of other competitors. That might work for you, but you might kill off your supply chain. If you fail to pay your suppliers, and often they are smaller than the businesses that we're talking about, they go. And you've got to find someone else. So to avoid financial Darwinism, you've got to think about who should I pay? Do I keep them in like the employees as well are an issue? We've got furlough. You're going to have to bring some of those back.
Yes, absolutely. That is the problem.
It is the problem of bringing people back into the business come September. And that ties in now with the discussions that you need to have with the landlords. How many units are going to reopen? How many are definitely going to close? And that debate is the one that, I think all of us as professionals are now engaging with our clients about. What does your business look like? You're going to lose some of the units for sure. You're never going to reopen on that. And what does it look like?
So the lease is a huge question for me, obviously, and I do want to take advantage of the current state of this economy. However, I've got employees. Should I start consultation program now within furlough, and is it possible? I've heard there are some rumours that at the minute that I start implementing a consultation process, the government will withdraw the furlough scheme, which will, of course, will mean the end of my business.
Yeah. Brian, if you want to take that one.
It's eminently possible to deal with employees and start a consultation process while they're on furlough. In actual fact, it's something that's something that people need to look at quite actively. The furlough scheme is going to start to unwind over the course of the coming months. You've got to make your business and put your business in a position where it's capable of moving forward with the resources that you need. And unfortunately, that's not the way it used to be. We're starting to see job losses in the sector. We're starting to see job losses in a number of sectors. The fact that those employees have been furloughed, the job retention scheme was a fantastic piece of work by the government, and all the levers they pulled are clearly designed to preserve jobs and preserve companies. But the reality is, your company, by the sounds of it, and also based on the fact that you are going to be in a different world once you have opened up, is not going to need the level of staff that it has historically.
Oh, absolutely.
You're going to have to look at your, not only your store costs, but also your head office costs.
It comes to a point, does it not, that the scheme is there for job retention, and if the job is now redundant, it really is the point that you've got to say, well, I shouldn't be relying on furlough. Brian's absolutely right. If the furlough scheme wasn't there, that would have caused significant waves of redundancy, which certainly in the first week of the closure, we were being inundated with inquiries about how do I make my staff redundant, and that was in the hospitality and leisure side. So that saved millions of jobs immediately, but it doesn't do that permanently. It can't do that permanently. The government can't afford to pay people not to work.
And likewise, your business can't afford to pay all your staff based on the fact they're not going to have it's not going to have the income, the profitability levels that it has done historically. Now, it may be over time, over the course of the next 6, 12, 18, 24 months, you can actually re-gear back up again as you actually get clear sight of how your business is going to move forward. But right now, you just can't produce those numbers.
So it's very clear to me, I've spent the last 2-3 months applying for my loans, trying to guess where the market's going to go, but it looks as if I need to start looking at my restructuring plan. In terms of landlords and restructuring leases, it may be too early to do it, because I would want to have some wriggle room, going forwards. And I don't think landlords, although that they may have effectively given up hope on recovering their March rents, although they did fight very hard initially, they're now looking towards recovering their June rents. I'm reluctant to give them any money for June because, again, I'm looking into the abyss. I don't know what's going to happen. And I sense that the new focus with this bill is going to be the September quarter, where it's effectively make or break for this economy, I sense. I don't know, David, is that, you're talking to landlords, do they know what's coming?
I think that they are silent. Give credit to Brian Bickle from Shaftesbury for saying that the model is broken. Very brave statement. Where are the other landlords? I went on one seminar, and one of the leading central London landlords, we were talking about sustainability, and the landlord was talking about the green energy in their building. No, I don't. I think that maybe the fear is too much to voice it, but it's time to roll the sleeves up and actually get on and start talking about it, because obviously the longer this goes on, the bigger the issue. I will say something else, and there was another organisation who, people ask me about issues at turnover rents, what it should be. There's an organisation called the RICS that's been around for 150 years with a £92 million turnover, right? That spends £13 million a year on promoting their brand. Where are you? You've got us into a lot of this mess potentially, with the arbitrations that can't be disputed. Where are these organizations to kind of bring landlords and tenants together? This is serious stuff. And ultimately, I think what you guys potentially can offer in terms of advice, at least that is a way of a limited company trying to restructure their business and go forward one way or the other. And they will, all being well, come out in a new way. But in terms of landlords, this is the penny is starting to drop, but I don't think anything like quick enough. And it's time to wake up.
Well, I'm going to say it again because I've heard this phrase time and time again. We are in unprecedented times. we can look at the signs, we can look at the economies. No one really knows what's going to happen. Time is the only commodity that I need to find, to actually make a balanced, judgment on how I trade my business going forward, and the decisions I need to make today. In terms of putting a corporate restructuring program together, it's obvious that the government's decided that we need to get out back to work. So it looks as if, as a director of a business with the responsibilities of employees and the supply chain below me, I need to now formulate that restructuring program. Brian, I know it's difficult because you can't generalise, but in terms of what sort of shape, and I'm conscious of time because I understand that there are a number of questions coming through on the floor that I think we should address. In terms of where we are here, how do I get from here to the panacea of the insolvency bill, whatever that offers, and then effectively make sure that effectively I have a business that could survive a second wave if in fact there is one?
Well, I guess, effectively, if you think about it as walking a tightrope, you've got a number of competing issues. I mean, one, the fact the company's insolvent, but there has been legislation put forward which obviously removes some of the issues with wrongful trading. You've got to obviously understand what your business is going to look like, or what you think it's going to look like in the near future. You've got the potential, if you need the platform now, to look at a CVA and start work on that. The bigger thing in my view at the moment is if you can get a clear sight of what you need to do and you can execute that effectively over the course of the coming weeks, you can put yourself in the best possible position to actually take the next step forward. That needs to be done with advice. You need to have formulated suitable contingency plans. You need to make sure that if there's a bump in the road, you can actually address it. It's about engaging with your creditors, engaging with your landlords, having those conversations, drawing out what is achievable, and then actually evaluating whether what is available to you is actually sufficient for what you need. That's the jump-off point where you start to look at, is this a consensual deal? Is this something that needs to go down a formal route? Is the business actually fundamentally viable? Or is this literally a matter of it has to be a formal insolvency process?
Okay, so Vernon, in terms of trying to summarise here, the timeline, 1st of July, 4th of July, my casual dining business comes back to life, albeit it seems to be an extension of Deliveroo at the minute. What is the timeline? David's going to suggest talking without prejudice to landlords to scope out where they sit in terms of taking back some leases, surrendering leases. But I have a point here. At the moment, my leases in the neighbourhoods are doing really well. My leases in city centres are dead. Sorry to associate an animal with my leases, but my dog leases are the ones in the neighbourhoods. So I understand that I'm in this catch-22 position. I want to have my cake and eat it. Am I just going to have to drive my business and hope that this bill provides a solution?
The bill won't provide the solution to what is a fundamental problem of your business. The insolvency tools are there to assist the restructuring of saving of companies and saving of businesses. But fundamentally, if your business is flawed, you have to take steps which are operational as much as anything else. And that means looking at those sites which are never going to make money again and looking to close them. We are beginning to talk to landlords in some circumstances about surrenders of lease, and they are being more realistic than they would have been but for COVID, quite rightly so. But landlords don't necessarily want the sites back. So strangely enough, then they come into different kinds of agreements regarding those sites, which may be you occupy at no rent for a period of time and we're trying to find a tenant. And practical solutions between the tenant and it goes back to David's point. If you're up front with these people, with your landlords and go through, then deals can be done which are effective. And if you're on a no rent for a period of 12 months, you can wind down that operation, or possibly in 12 months time, the landlord may be saying, well, actually, prefer to have you as my tenant paying a service charge, avoiding the business rates or otherwise for the landlords, which might otherwise fall. It's aspects like that which make the possibilities now are much more readily available.
Right, chaps, I'm conscious of time, and there are a number of questions from the floor, and we do have some that we're going to address in the meeting. Can I possibly direct some of the questions to you? Okay, this is from Matt Fountain. What is your opinion on lease deals where that was signed just before to the outbreak, the new normal, now legally bounding? How do we revisit these deals or exit the deal altogether? David.
Well, I think it's clear that covenant is no longer what it was. Some may be extreme and say it was dead. Others will say that it's really not the issue. I think that if you've got to fit the unit out, for example, if you've signed a lease where you've actually got to fit the unit out, I saw one landlord this week saying, I'll tell you what, you've got to fit the unit out. We'll give you rent free till July 2021 and half rent till July 2022, but just don't not fit the unit out, carry on as before, but we will give you much extra help than before. I think that ultimately, what you signed before is not what is now, and therefore, it's definitely about a renegotiation. If you can't do a renegotiation, then it's about taking advice from, insolvency lawyers and insolvency practitioners and doing what you've got to do to survive. But it's a step process, direct to discussion, maybe engaging with an property advisory firm like ourselves, then getting some insolvency advice, then an insolvency practitioner, and it just keeps on going, escalating. And I suppose it's much more so if you've just signed a lease and you're not even operational because you don't even know what that unit's going to be like, Matt. You've got no idea how well you're going to trade there, and therefore it's much more acute with those new agreements.
Thank you, David. This is a statement from David Stevens. Very fair point about RICS and their silence, lack of leadership. Very, very disappointing. Thank you, David. I'm just going to try and mix it up legally, from a legal point of view. What do you see as the format and main points for the bill being introduced next month? That's a huge subject. But
it is. I could spend the next hour. I quickly did. You've got two aspects of the bill. One is the temporary measures, which in theory run out at the 30th of June. I think in all likelihood they're going to be extended. We've been having a discussion about that. There's certainly a lot of industry rumour that they will be extended to August/September, and that's the temporary measures preventing winding up statutory demands and the like. You've got the permanent measures, which are, as we've discussed, the moratorium provision, and the restructuring plan, which is new to our legislation, new bits of tools for the toolkit. The thought process is that they will come into force, as I said, in July. As I said, could be the end of the month, or otherwise this month or July. They will become effectively immediately. This is something on the moratorium, for instance. Just this week, we've had some indication of the government's giving some advice to the monitors through a sort of code of conduct. The monitors who will be responsible for ensuring that the company remains eligible and remains capable of being rescued. That proposal has, as I said, got some temporary measures around it, so it's going to come into force immediately, which is somewhat of a surprise. I was expecting it was going to be September when the secondary legislation, when all the rules and regs regarding it were brought into effect. No, there's going to be some temporary rules and regs, which mean it's effective immediately, which shows the government is absolutely committed to having this new tool available for it. So that's the roadmap.
Very good. Yes. I mean, my example, going on to another question from an anonymous attendee, basically was based around a large business with a number of, multiple units. The question here is, a lot of these procedures to assist with leases are useful to bigger businesses with multiple chains, but what options can be considered by the small one-site business on the high street? David?
Yeah, I'm really, really glad to see this question. And I have opened myself up literally probably 20 hours a day to talking to these types of people, just telling them what they should be doing and giving them advice on how to negotiate and deal with landlords themselves, because obviously the costs maybe are too high for them to consider. You know, not everybody can do, you know, these restructurings. I'm actually looking at launching a service myself for this called a rent mediation service, where essentially you bring landlord and tenant in the same room or the same Zoom, you know, for 3 hours. One of our couple of our people are actually licensed mediators, and for, like, you know, a fixed fee sum, you know, let's get in the room, let's turn off all our other interests, and let's just try and focus on a deal. And I think that something like that, a controlled environment mediation service, could be a good thing for the smaller, you know, for the smaller one-site businesses, because they can just sit there and know that they're coming in with a willing landlord, willing tenant, and just get it done and move on, hopefully, with focusing on actually building up a decimated business model.
If I can add as well, I think there's one extra element to this. The tenant business needs to provide as much financial information and business plan as they can to the landlord. It's the same. You know, we've talked about CVAs and administrations and moratoriums. I agree with David. The vast majority of businesses are small businesses, and they won't be using those tools. But what they do need to do is still have a plan. And that plan needs to make sense to their business, but also needs to make sense to the landlord. And they need to show that and evidence it and show their figures, what they think they're going to do. And that's the key to coming to a successful concluded negotiated settlement with the landlord.
Yeah, I would also say that a CVA is not precluded from being used by a small company.
No,
Absolutely.
true. Can work.
Brian, on that note, the last question from the floor, but I will address a question from the perspective of a senior debt holder, such as a bank. Brian, from David Stevens, what happens to any dilapidation provisions on leases where CVA means tenants can walk away from leases and sites? Do these also fall away, e.g. on the restaurant group's level 4 sites, which they intend to close, walk away from?
Well, they can certainly be compromised under the terms of the CVA. So, you know, what you would have to do in some respects is actually address them. If and it's been done multiple times before, you'd actually apply some degree of dilapidations provision to each site, probably based on a square footage basis and a value per square foot. And they would be compromised along with the other creditors that have been compromised as part of the process. As long as you've got the cramming power from supporting creditors, I would imagine. Well, that's the thing. Under a CVA, you would normally do that. Under a moratorium, it's an offer to a class of creditors. So I can't see at the moment that there'd be any reason why you couldn't address those as part of it. As long as you're consistent, as long as it's fair and equitable. And the reality is, you've actually said at this particular point that the business cannot meet those liabilities. Otherwise, you wouldn't be adopting these processes. So yes, they can be dealt with, and they can be, I suppose, quantified and paid. Thank you, Brian. I know we're up against time. I almost knew we were going to run out of time. I am going to take deal with a question from Andy Williams and Handelsbanken that he previously submitted. This is from the perspective of a lender. How should lenders react when faced with landlords whose potential revised lease arrangements make existing deal structures unviable? And what remedies are available at the current time, given most legal charges facility documentation will include lender consent to lease clauses? Start with vendor, with Vernon, Brian, and David. Okay. From a legal point of view, you can still enforce your charge against the landlord creditors. So you, through qualifying floating charge, which you're likely to have, you can enforce. Arguably, you couldn't enforce by way of winding up, but why would you? But you couldn't because of the fact that the non-payment is almost certainly due to COVID. But as I said, the key enforcement remedy is still there. It's a question in just the same way as the tenant and landlord situation between the landlord and its lender. They've got to negotiate. They have to negotiate and renegotiate a deal. And the government is desperate for the stakeholders to seek to try and negotiate deals to keep the wheels of the economy going, rather than to see mass insolvencies.
And, for all of us, I'm sure on this panel, we want to avoid insolvencies and that's why we're here. We're trying to provide advice and solutions which will avoid that. And it's just the same for the lenders as well.
Okay. Brian, obviously.
I'd say firstly, I think firstly, the one thing to remember is that probably across the board, there are going to be significant breach covenants and issues.
Yeah.
The original lend, the valuation's probably been impacted. Capital values are taking hits. Whichever way you look at it, there are going to be issues probably on any legal agreement and, bank facility, terms, unless you've got an exceptionally strong business who hasn't really been impacted by the pandemic. Going back to the global financial crisis, the reality is there had to be a degree of flex. It's about revisiting the covenants, probably giving some degree of comfort that you can actually have a technical breach and waive it for a period, and then hopefully over the course of time either manage the client back into formula, and it could be some considerable period of time, or more likely define what your new formula is going to be. But the reality for most things, I think it's about working together. There's been a complete impact across the entire spectrum. I find it interesting that the chances are that you've got a landlord who's breached their covenants and their tenant has breached their covenants. So you've actually got two stakeholders who don't want the same, who hopefully want to get to the same outcome, which is that there's back to some level of parity.
Yeah, we're all on the same boat by the looks of things. David, I'm going to give you a specific question. Question for David. How common are rent suspensions triggered by lockdowns for new leases? How will a lockdown at a rent review date affect the review? Will landlords try to include lockdowns as a disregard when negotiating heads of terms?
Well, look, it's a legal question. I'm not a lawyer. However, I will say that there's this thing called derogation of grant, which means that for a lot of the controlled environment spaces like shopping centres, or where you were actually not allowed to go into those premises during lockdown, so you were not physically allowed to get access to your shop or restaurant, there is an argument in that period then you shouldn't have paid rent, and that is a legal argument which is growing, and it's quite a significant argument. In terms of what you're going to negotiate in HOTS going forward, I think yes, things relating to pandemics and things like that is obviously going to come in. But I think the key thing, these are all little things at the bottom. The key thing is let's have a relationship. In the same way that the operators have a relationship with their food suppliers, landlords have to have a similar relationship with their tenants, and there should almost be an ongoing review. How are you doing? What's your turnover? I don't believe I've ever been asked that often by landlords for a business plan or a revised business plan of, is your rent sustainable? How are you going to afford to pay this? As long as there's a rent deposit in place or a covenant in place, no questions were asked. And so I think it's really just bouncing it back to this issue of the relationships need to change. But yes, there is a lot of legal activity around derogation of grants, and I'm sure people will look and speak to their lawyers about that specific point.
Vernon?
I sort of perhaps end on a sort of wider point. I think you asked with the restructuring of the leasehold portfolio in the high street, will it reinvigorate the high street? And the answer is yes. COVID has effectively been the accelerator of change. We've talked earlier about the difficulties we have had for the high street, whether it's Brexit, exchange rates, demographic changes, move towards the online, etc., etc., etc. This is a problem that has been building up for some years and would have taken some years to resolve. COVID is the accelerator. So if we can get to a situation where we are restructuring, whether it's informally by negotiation or whether we have to use process, but if we can restructure the leasehold issue, I think it would make a significant addition to saving the high street. So that was sort of possibly a slightly answered a different question, if I may. But as we're running out of time, I thought
we are. Yeah. There are a number of unanswered questions, particularly John Wills, David Stevens. I think Chris Sullivan, we need to address yours. Kay Luckham, and it goes on, David Muxell, Tony Graham. We will direct those to David, Vernon and Brian outside this webinar, and I'm sure they'll come back to you by email. I'm going to thank our panel, thank our guests in attending, and of course thank my team in putting this webinar together. We are, as a firm, putting webinars together live on stream every Friday, so please stay tuned. All I can remain to say is have a great day and a great weekend, and of course stay safe. Thank you all.
You can find out more about how we are advising businesses at this time on our website.